Hi everyone, welcome to the channel. If you're new here, please make sure to hit the subscribe button, make sure the bell's on. We go live every Saturday at noon to discuss various cases, orders, current events of the day surrounding the true crime genre. We also have random impromptu lives, and you can find me and my husband over on Patreon, where we are far more casual and post a little more regularly. Today we're reading part 2 of the Scott Peterson habeas corpus writ order that denied a new trial. Part 1 is on the page. If you have not read that, that encompasses the first half. And we broke this off into 2 sections so people can come back and listen, do all that. So we're picking up on the legal standards is where we left off. So a review of the witnesses, their testimony, background of the case, all of that can be found on part 1. So kicking off on legal standards, Section A, applicable legal principles. Again, also I'm going to skip over citations just because they take up such a large part. I'm also going to read footnotes at the end of whichever section that they are leaving off on. So at the end of that sentence, I'll pop over to the footnote. So it's not, completely interrupting a thought. Applicable legal standards. A criminal defendant has the constitutional right to trial by an impartial and unbiased jury. That's the 6th and 14th Amendments of the Constitution. The right to unbiased and unprejudiced jurors is an inseparable and inalienable part of the right to a trial by jury guaranteed by our Constitution. An impartial jury is one which no member has been improperly influenced, and every member is, quote, capable and willing to decide the case solely on the evidence before them. Thus, the constitutional right to an impartial jury is violated even if only a single juror is biased. Skipping down to footnote 33, although the evidence of Peterson's guilt is overwhelming and not in reasonable doubt, the strength of the evidence is not relevant when considering the question of juror misconduct, and it has not been considered as part of this proceeding. During jury selection, the parties have the right to challenge and excuse candidates who clearly or potentially cannot be fair. Voir dire cannot serve this purpose if prospective jurors do not answer questions truthfully. A juror who conceals relevant facts or gives false answers during the voir dire examination thus undermines the jury selection process and commits misconduct. Such misconduct includes the unintentional concealment, that is, the inadvertent non-disclosure of facts that bear a substantial likelihood of uncovering a strong potential of juror bias. When a petitioner makes a claim of juror misconduct, the court conducts a 2-step inquiry. The court must first determine whether there was any juror misconduct. Only if we answer that question affirmatively do we consider whether the conduct was then prejudicial. If the petitioner establishes juror misconduct by the preponderance of the evidence, then the court proceeds to the 2nd step of the inquiry, whether that misconduct requires reversal of the judgment. Once a court determines a juror has engaged in misconduct, a defendant is presumed to have suffered prejudice. Once a court determines a juror has engaged in misconduct, a defendant is presumed to have suffered prejudice. I will note that they left out the citation for that one, okay? It is for the prosecutor then to rebut the presumption by establishing there is no substantial likelihood that one or more jurors were actually biased against the defendant. This presumption of prejudice may be rebutted by an affirmative evidentiary showing that prejudice does not exist, or by a reviewing court's examination of the entire record to determine whether there is a reasonable probability of actual harm to the complaining party resulting from that misconduct. Burden of proof. Because a petition for writ of habeas corpus is collateral attack on a presumptively final criminal judgment, the petitioner bears a heavy burden initially to plead sufficient grounds for relief, and then later to actually prove them. To obtain relief, the petitioner must prove by a preponderance only of the evidence the facts that establish entitlement to relief. For purpose of collateral attack, all presumptions favor the truth, accuracy, and fairness of the conviction and sentence. The defendant then must undertake the burden of overturning those. Society's interest in the finality of criminal proceedings so demands, and due process is not thereby offended. Where, however, the court determines that a juror has committed misconduct by concealing, quote, relevant facts or by giving false answers, unquote, during their jury selection, the court then presumes prejudice. And that burden shifts to the people to demonstrate the absence of that prejudice. Any presumption of prejudice is rebutted, and the verdict will not be disturbed if the entire record in the particular case, including the nature of the misconduct or other offense and the surrounding circumstances, indicates there is no reasonable probability of prejudice. No reasonable probability of prejudice. In other words, no substantial likelihood that one or more jurors were actually biased against the defendant. Further, in other words, the test asks not whether the juror would have been stricken by one of the parties, but whether the juror's concealment or non-disclosure evidences a bias. This objective standard is a pragmatic one, mindful of the day-to-day realities of courtroom life and of society's strong competing interest in the stability of criminal verdicts. Our Constitution demands that jurors be selected from a cross-section of the community as a means of ensuring the defendant's right to an impartial jury. This requires a process that allows for varied levels of education and diverse backgrounds and experiences, which is both the strength and the weakness of the institution. The criminal justice system must not be rendered impotent in quest of an ever-elusive perfection. Jurors are imbued with human frailties as well as virtues. If the system is to function at all, we must tolerate a certain amount of imperfection short of actual bias. The United States Supreme Court has also recognized that jurors are not held to a standard of perfection. The varied responses to respondents' questions on voir dire testify to the fact that jurors are not necessarily experts in English usage. Called as they are from all walks of life, many may be uncertain as to the meaning of the terms, which are relatively easily understood by lawyers and judges. But moreover, the statutory qualifications for jurors require only a minimum competency in the English language. Actual bias is, quote, a state of mind in reference to the case or to any of the parties, which will prevent the juror from acting with entire impartiality and without prejudice to the substantial rights of any of the parties, unquote. Indeed, a sitting juror's actual bias, which would have supported a challenge for cause, renders him, quote, unable to perform his duty, unquote, and thus subject to discharge and substitution. Generally, the gravity of misconduct correlates with the amount of proof necessary to rebut that presumption of prejudice. In addition, the nature and seriousness of the misconduct, courts have recognized the strength of the evidence of misconduct and the probability that actual prejudice may have ensued and is relevant to a determination whether the presumption of prejudice has actually been rebutted. A juror's intentional concealment is strong proof of prejudice, but it is not dispositive of actual bias. An unintentional non-disclosure may mask actual bias, while an intentional non-disclosure may be a reason unrelated to bias. However, if an unintentional concealment is caused by an honest mistake on voir dire, it, quote, cannot disturb a judgment in the absence of proof that the juror's wrong or incomplete answer hid a juror's actual bias. Courts have relied on specific factors in determining whether a juror intentionally concealed relevant information. A juror volunteering undisclosed information after the trial is one of them. They do cite People versus San Nicolas, and I'm going to read these ones that are coming up because they're giving examples from other cases. So I want you to know what cases I'm talking about. So back to the document itself. They're talking People versus San Nicolas. It's a 2004 case. Citation is 34 Cal 4th 614 through 646, summarized as 2 months after trial, the juror informed defense counsel of having been stabbed 15 times when he was a teenager. If the juror had formed improper opinions about the case and intended to act in ways prejudicial to the defense, common sense suggests that the juror would have simply remained silent. Whatever the fuck that means. Sorry. Pretrial publicity, pretrial questionnaires, or voir dire may also alert a juror to the importance of their undisclosed personal experiences and trigger relevant memories. If the court finds that a juror, quote, had a reason to anticipate the importance of her own, and then it's fill in the blank, experiences while completing the pretrial questionnaire or participating in the voir dire process, her non-disclosures may indicate an attempt to conceal them, which could in turn indicate juror bias. Such a conclusion requires the line of questioning by counsel and of the court to be sufficiently cleared through. In addition to these specific factors, courts assessing whether a non-disclosure was intentional also look at the reasons given by the juror for failing to disclose the information. Courts may find a non-disclosure to have been inadvertent when a juror credibly, and they have italicized credibly, provides a reason for the non-disclosure. That's interesting. We'll talk about that in the discussion. Finally, a juror's partiality can be supported by the surrounding circumstances of that misconduct. And then it's going to Henry Hitchings, 6 Cal 4th at page 120, juror violated her oath as a juror by discussing the case before the trial was over. Well, okay. Subsection C, factors regarding credibility of the witness. The credibility of several witnesses is critical to resolving the factual allegations in dispute. The Judicial Council of California Criminal Court Instructions, it's CalCrim for short, and California Civil Jury Instruction, which is CACI, it's CACI, prescribes the factors to be considered by jurors in determining witness credibility in criminal and civil proceedings. The court finds that these factors and the other instructional guidance regarding credibility provided by the Judicial Council are appropriate in guiding this court's determination of credibility in this proceeding. Those factors will include: how well was the witness able to remember and describe what happened? What was the witness's behavior while testifying? Did the witness understand the questions and answer them directly? Was the witness's testimony influenced by a factor such as bias or prejudice, a personal relationship with someone involved in the case, or a personal interest in how the case is decided? Did the witness make a statement in the past that is consistent or inconsistent with his or her testimony? How reasonable is the testimony when you consider all of the other evidence in the case? Did the witness admit to being untruthful? Has the witness engaged in other conduct that reflects his or her believability? Was the witness promised immunity in exchange for his or her testimony? Fact finders should not automatically reject testimony just because of inconsistencies or conflicts. As the Judicial Council has explained, it's appropriate to, quote, consider whether the differences are important or not, end quote. The law acknowledges the fact that people sometimes honestly forget things or make mistakes in what they remember. Also, two people may witness the same event, yet see or hear it differently. Fact finders are instructed to use their common sense and experience when evaluating the testimony and to view the reasonableness of the testimony considering all of the other evidence presented in the case. But finally, if a witness is not truthful about something important, the fact finder, quote, may choose not to believe anything that the witness has said, unquote. However, if a fact finder thinks the witness did not tell the truth about some things, but told the truth about others, the fact finder may accept the part that they find to be true and ignore the rest. Evidence that a witness has lied under oath on another occasion is directly relevant to the witness's credibility today. Big old citation. With these principles in mind, the court now turns to petitioner's claims against the backdrop of the record of evidence. So here we've got the findings of facts and the conclusions of law. The court finds that several of the answers provided by juror number 7 on her juror questionnaire were false in certain respects. This does shift the burden to the respondent to demonstrate that she was not biased against the petitioner. The court finds that respondent has sustained that burden. The court concludes that juror number 7's responses were not motivated by pre-existing or improper bias against petitioner, but instead were a result of a combination of good faith misunderstanding of the question and sloppiness in answering. The court findings are based on the evidence in the record, including an assessment of the credibility of juror number 7 and other witnesses pursuant to the facts recited above. Footnote 34, Evidence Code, Section 780 lists similar factors for consideration for determining the credibility of a witness. These factors include any matter that has any tendency and reason to prove or disprove the truthfulness of her testimony, including but not limited to the following. Her demeanor while testifying in the manner she testifies, the character of her testimony, the extent of her capacity to perceive, to recollect, or to communicate any matter about which she testifies, the extent of her opportunity to perceive any matter about which she testifies, the existence or non-existence of biased interest or other motive, a statement previously made by her that is consistent with her testimony at the hearing, a statement made by her that is inconsistent with any part of her testimony at the hearing, the existence or non-existence of any fact testified to by her, her attitude towards the action in which she testifies or towards giving of testimony at this hearing, her admissions of untruthfulness. Now I'm going to break it down. So subsection A is regarding juror number 7's answers to questions 54A and 54B. The court finds these were false. Read together, questions 54A and 54B were asking juror number 7 if she had ever been involved in a lawsuit, and if so, as the plaintiff, the defendant, or both. Respondent contends petitioner did not demonstrate that juror number 7's failure to list her petitions for a restraining order was misconduct because juror number 7 did not understand that the request and hearing for a restraining order was a lawsuit because it was not, quote, a suit for money or property, end quote. The court disagrees. With respect to question 54B, it is clear from her testimony that juror number 7 identified herself as a plaintiff when she filled out the form for the restraining order. She testified that she understood what was meant by plaintiff and defendant in the petition and explained that she was the plaintiff because she was the person asking for the restraining order. In the petition for her restraining order, the word plaintiff appears at least 10 times. In addition, juror number 7 testified that she did, in fact, seek money damages from Ms. Kinsley in another proceeding after that restraining order. That proceeding was in Santa Clara Superior Court. While the records of that proceeding were not made available and are not part of this record, juror number 7's testimony was clear, and it was a lawsuit for money. Therefore, the court finds that juror number 7's answers to question 54A and 54B were incorrect. There is a meaningful argument that, quote unquote, incorrect in the context of this case does not have to mean false, because the questions at issue require the interpretation of legal terminology, and juror number 7 was an unsophisticated layperson. Although the court credits this argument, it finds that it is better addressed in the context of whether juror number 7 was motivated by bias in giving her answer. Accordingly, the court concludes that the legally incorrect answer provided by juror number 7 was false, and the burden will shift to the respondent. Because a juror who conceals relevant facts or gives false answers during voir dire does commit misconduct. Subsection B, regarding juror number 7's answer to question 74, the court finds it was false. The second issue presented concerns juror number 7's response to question 74. Have you or any member of your family or close friends ever been the victim or witness to any crime? The court finds that juror number 7's response to question 74 was also false, and for several reasons. And let me pop down. We got a footnote. Ooh, it's a big one. Okay. Footnote 35, as noted above, petitioner appears to have abandoned the legal issue regarding question 72 on the questionnaire, which reads, have you ever participated in a trial as a party witness or interested observer? Juror number 7 checked the box no, but petitioner failed to cover question 72 during the 2022 hearing or in his post-hearing briefing. But he has not formally waived or abandoned it. Assuming it was not abandoned, there is no evidence in the record that juror number 7 was ever party witness or interested observer in a trial. The record evidences that juror number 7 dismissed all the lawsuits against Ms. Kinsley in Santa Clara County Court before it went forward to trial, and the restraining order hearing was not a trial, as that term is commonly understood. A hearing is a court appearance on a specific matter, and then they just describe the difference between the two. First, juror number 7 testified that she heard Miss Kinsley stand outside her home yelling for her and Mr. Whiteside to come outside, quote, so they could fight, end quote. And then she kicked in juror number 7's front door. Juror number 7 also knew that Mr. Whiteside had been a victim of Mrs. Kinsley's behavior that day when she slashed his tires and sprayed him with mace. Juror number 7 admitted on the stand that she considered kicking in the front door and flashing of his tires to be crimes. When asked why she called the police that day, juror number 7 conceded that it was because, quote, she thought a crime was being committed, unquote. Second, juror number 7 saw Miss Kinsley following her in her car and testified that Miss Kinsley was showing a history of being, quote unquote, stalkerish. Again, when asked by the petitioner whether she considered Miss Kinsley stalking her to be a crime, juror number 7 answered, sure. Third, while juror number 7 testified that Mr. Whiteside did not assault her during the incident in her home in November of 2001, she admitted that she hit him, consequently admitting that Mr. Whiteside had been the victim of her assault. Similar to the previous questions, whether juror number 7 had been the victim or witness of a crime, raises issues regarding the interpretation of terms that have particular legal meanings. However, the issue before the court at this stage of the finding is whether or not juror number 7 misunderstood those terms. It is whether she gave an incorrect answer or not. For the purposes of question 74, the court does find her incorrect response to be false. Subsection C. Juror number 7, this is a finding of law. Juror number 7 was not biased against petitioner. We're kicking it right off with a big old footnote, down to footnote 36. Petitioner relies on the case of Dyer versus Cauldron, Ninth Circuit, 1998. I won't give the citation, you can look it up, to support his contention that the evidence of the Kinsley incident demonstrates that juror number 7 was impliedly biased against him. As a first point, while actual bias is a factual question, implied bias is a legal determination that may exist in those extreme circumstances where the relationship between a prospective juror and some aspect of the litigation is such that it's highly unlikely that the average person could remain impartial in his deliberations under those circumstances. These extreme circumstances might be a revelation that the juror is an actual employee of the prosecuting agency, that the juror is a close relative of one of the participants in the trial or the criminal transaction, or that the juror was a witness or somehow involved in the crime itself. They are citing Smith v. Phillips. So they have circumvented the case that was put into evidence. They are quoting the exact fact findings pattern in Smith v. Phillips, 1982, 455 U.S. 209 at 222, written by Justice O'Connor. Wow. In Dyer, the federal court found implied bias after the juror, when questioned by the trial judge, told the judge that she believed her brother's death was an accident. In fact, the brother had been pistol whipped and shot in the back of the head. Shortly after his shooting, the juror sued the defendant that shot him. In addition, the juror's mother, with whom she lived, testified at the preliminary hearing involving the brother's death. There was also evidence the juror's husband was in jail and had been arrested on a rape charge a month before the trial. Here, the facts are completely distinguishable from those in Dyer and do not support a finding of such an extreme situation. What the fuck? Dumb. Okay. I don't know why we just detoured for that, but anyway. Back to Section C, juror number 7 was not biased against petitioner. It then cites down to footnote 36, which we just read. Having found that juror number 7's failure to disclose, number 1, the incident involving Mrs. Kinsley, number 2, the civil lawsuit against Miss Kinsley, and 3, the incident involving her hitting Mr. Whiteside, constitutes misconduct, and the court turns to the next issue. Has the presumption of prejudice based on the findings of misconduct been rebutted? In other words, in reviewing the record as a whole, is there no substantial likelihood that juror number 7 was actually biased against petitioner? For all the reasons set forth below, the court finds that juror number 7 did not engage in prejudicial misconduct when failing to disclose her prior involvement or the involvement of her family and close friends in these legal proceedings. Number 1, juror number 7's non-disclosures were honest mistakes. Juror number 7, and these are going to be now listings of the reasons. So Roman numeral 1, juror number 7 was a credible witness. Applying the factors set out in Evidence Code Section 780 of CalCrim, 226 of Casey, this court finds juror number 7 to be credible. Juror number 7's demeanor while testifying was appropriate, respectful, and forthcoming. CalCrim number 226. Although she appeared somewhat nervous when she initially took the stand, given the publicity in this case and the accusation of misconduct, that nervousness was, in the court's view, appropriate and justified. During the 2 days of questioning that followed, juror number 7 never lost her temper or behaved in any manner other than someone who was respectful of the process and understood the seriousness of the proceedings. Juror number 7's answers to the questions presented to her were forthcoming. Juror number 7 answered the questions presented to her. Juror number 7 answers were direct and not evasive, and she spoke in a clear manner. When she was unable to understand a question, she so stated. When she was unable to recall an event, she also stated that. Despite the passage of time, juror number 7's memory of the underlying events giving rise to this proceedings were, for the most part, clear. The Kinsley incident occurred in 2000, the Whiteside incident in 2001, yet as to each, she was able to describe what happened to the best of her recollect. Juror number 7 credibly and directly explained why she requested a restraining order against Miss Kinsley, the lifestyle that she and Mr. Whiteside shared, and the evidence that led to his arrest in 2001. Her reasons for dropping the civil lawsuit against Miss Kinsley and her reasons for reaching out to an acquaintance who was also who was also a police officer when she claimed that Miss Kinsley violated the restraining order, were well explained. Although petitioner alleges that juror number 7 was biased against him when she filled out her questionnaire in 2004, there's no evidence that her testimony during this proceeding was influenced by bias or prejudice. Juror number 7 requested and was granted immunity. Nothing that she said could have been used against her by the district attorney, but to put it another way, she had every reason to be truthful during her evidentiary hearing. In addition, there is no evidence that juror number 7 harbored any personal interest in how this petition is decided. Roman numeral 2. Juror number 7 was not impacted. Well, this is a quote. Juror number 7 was not, quote, impacted by the trauma of having her own unborn child threatened, end quote. After hearing and observing juror number 7 during the 2 days of testimony, the court finds that far from being a traumatic life experience as painted by the petitioner, the incident involving juror number 7, Miss Kinsley, and Mr. Whiteside can be described, for lack of a better word, as a love triangle. In this context, it's noteworthy that at the time of the September 23rd, 2000 incident, juror number 7 was approximately 30 years old, and Mr. Whiteside was 22 years old. Miss Kinsley was Mr. Whiteside's ex-girlfriend. Juror number 7 was approximately 3 months pregnant with his child. Juror number 7 testified that while Mr. Whiteside had all of his belongings at her home, he did not always live there. She specifically described Mr. Whiteside as someone who fit the model for the song Papa Was a Rolling Stone. During oral arguments, petitioner described the relationship between she and Mr. Whiteside as a complex one, underscoring the on-again and off-again nature of the relationship is petitioner's allegation that by the time juror number 7 filed for a restraining order 2 months after the Kinsley incident, juror number 7 and Mr. Whiteside appeared to have already broken up. It harkens back then to an exhibit number 45 from the HCP. What is there? Exhibit 905. Number 4, how is it that you know the defendant? Marcella is my ex-boyfriend's ex-girlfriend. That was juror 7's answer. Moreover, before juror number 7 sought the restraining order, she called Miss Kinsley to, quote, try to put a stop, unquote, to Miss Kinsley's behavior as alleged by petitioner supporting documents. When that attempt failed, she proceeded with the restraining order to avoid, quote, handling it on the streets, unquote. Though by her own admission, she has been in many fights in her life, juror number 7 testified that at the time she was 5 months pregnant now, and, quote, rolling around like some dummies on the ground, unquote, could cause her to lose her baby. Understanding juror number 7's testimony needs to be put in the context of common sense and experience. And that's referring to a Casey number 5009, right? This is actually for the fact finder, but anyway, that's the sentence. Understanding Rochelle Niece's has to be put in the context of common sense and experience. There are several considerations that the court takes into account in evaluating her testimony. First, if any individual actually fears that another person would harm that individual or the individual's unborn child, it is not reasonable for that individual to actively reach out to the other party and ask them to stop the conduct. I guess. Second, juror number 7's background needs to be considered in the context of how she viewed Miss Kinsley's conduct. Jurors could represent a cross-section of the community and should. Juror number 7 was a part of that cross-section. She grew up in East Palo Alto, California. Let's zip on down. Between the years of 1983 and 2000, this is footnote 38, by the way, East Palo Alto struggled with high rates of violent crimes and gang violence. The crack epidemic had decimated the city, And by 1992, the city had gained a reputation of being the U.S. quote-unquote murder capital and was the nation's leader in per capita murders that year. So she grew up in a rough neighborhood. That's what that is telling us. She had only a high school education with limited training as a certified medical assistant. Her brother served time in state prison for a drug-related offense, and her mother was a methadone drug counselor. Okay. Juror number 7 testified repeatedly about the fact that she had been in many fights in her life, but she did not consider herself ever to be a victim. Witnessing her very candid demeanor when she described her life and her life experiences, this court finds her testimony vis-a-vis Miss Kinsley, while unusual, to be true. In addition, juror number 7 had 4 children with 3 different fathers and never married. When she appeared for jury duty, she had visible tattoos. Her hair was dyed a, quote, bright pinkish red color, unquote. As respondent argued, she appeared to be a juror that petitioner would want on his jury. Consistent with that argument is the fact that the trial court excused her for cause based on a financial hardship, but it was petitioner's lawyer, Mark Garagos, that insisted that she remain. Footnote 39. There is no indication in the record that juror number 7 did anything to resist the trial court's dismissal. She testified that when she was excused, she picked up her belongings and walked 3 chair lengths to leave the courtroom when Mr. Garagos insisted she remain. Had juror number 7 wanted to be on the jury to punish petitioner for what he did to Connor, it would be reasonable to conclude that she would have done more to resist dismissal in the beginning. Instead, she accepted the dismissal and started to leave. End of footnote 39. Petitioner correctly argues that juror number 7's application for a restraining order, which stated that she was seeking the order because she was, quote, in fear for her unborn child, unquote, is a past statement that on its face is inconsistent with juror number 7's testimony that she was not in fear of Miss Kinsley hurting her unborn child. Evidence that a witness has lied under oath on another occasion is directly relevant to the witness's credibility. However, in this context, the court also credits juror number 7's admission of untruthfulness. Juror number 7 admitted at the evidentiary hearing that she had been untruthful, and she candidly explained why she requested a restraining order against Miss Kinsley. In her own words, juror number 7 said she did not want to physically fight Miss Kinsley and risk losing her baby. Quote, she was going to deliberately hurt my child, but if we fought and rolled around like some dummies on the ground, then yes, I would be fearful that I would lose my child doing something stupid like that, unquote. Juror number 7 also admitted she was, quote, being spiteful, unquote, when she requested the restraining order be both for herself and her unborn child. She credibly testified that she had absolutely no genuine fear that Miss Kinsley was going to hurt her or her child. Juror number 7 testified on this point is purportedly supported by her alleged behavior immediately prior to and after seeking the restraining order. Juror number 7 twice initiated contact with Miss Kinsley as she testified, once allegedly by telephone just days before requesting the restraining order, and once after the restraining order was issued outside of the courthouse after her dismissing the civil lawsuit, she reported. In both instances, she was still pregnant with an unborn child, one of them covered by the restraining order. Juror number 7 conceded at the evidentiary hearing that she did call law enforcement about Miss Kinsley violating the restraining order approximately 2 years after it was issued. However, on the stand, juror number 7 stated again that she was, quote, just being spiteful, unquote. The incident that precipitated juror number 7 calling the police was a video of Miss Kinsley at a birthday party at Mr. Whiteside's mother's home, holding juror number 7's son, the prior unborn child that was the subject of the restraining order. The time the video was taken, juror number 7 was still in the hospital recovering from having just given birth to her subsequent child. Juror number 7 testified that she did not believe Miss Kinsley was committing a crime when she was with her son. She was actually being nice to my child, so it wasn't a crime. Again, stating on this occasion, quote, "I talked to the police out of spite," unquote. The court finds that juror number 7's testimony about her reasons for contacting law enforcement regarding a restraining order violation to be credible, given both the history between the parties and where juror number 7 was when the video was taken, in the hospital, having just given birth to Mr. Whiteside's second child. The court also finds juror number 7's non-disclosure of the lawsuit against Miss Kinsley to be an honest mistake. Juror number 7 forthrightly acknowledged she did in fact file a lawsuit seeking money damages against Miss Kinsley. Her testimony that, in her mind, she didn't sue her because instead of pursuing the civil lawsuit, juror number 7 asked the judge to, quote unquote, drop the action, is credible. Juror number 7's testimony is bolstered by the fact that after she asked the judge to, quote unquote, drop the action, she and Miss Kinsley made amends outside of that courthouse. Based on all of the recorded evidence, the court is not persuaded that juror number 7 was, quote, impacted by the trauma of having her own unborn child threatened, unquote, such that she was prejudiced against the petitioner. The court accepts and credits juror number 7's explanations and finds the non-disclosures to be inadvertent. Footnote 41. The court notes that there are examples of inadvertentness and mistakes made by trained professionals in this very proceeding. And then they talk about the witness that we talked about before that inadvertently stamped off on documents that weren't even from her police department. So that's in part 1 if anyone's interested in listening to that testimony. The court further finds that juror number 7 did not intentionally conceal information on the jury questionnaire to punish petitioner for what she had herself experienced when she was pregnant. The court finds credible that for juror number 7, these incidents simply did not cross her mind in the context of these questions as they were asked during the jury selection process. In juror number 7's words, quote, "I don't hold on to things. I just didn't remember. It just didn't cross my mind," unquote. Subsection 2. Juror number 7 was not a victim of domestic violence. So this is finding a fact. Finding a fact number 2. As explained above, Eddie Whiteside is the ex-boyfriend of juror number 7 and the father of her 2 youngest children. Mr. Whiteside lived with juror number 7 at the time of jury selection and was present during the Kinsley incident and later named as a witness to an alleged restraining order violation. He was also the named suspect in the purported domestic violence incident involving juror number 7. Purported. Neither petitioner nor respondent listed Mr. Whiteside as a witness. Rather, it was petitioner's intent to call Mr. Whiteside as a rebuttal witness to impeach juror number 7's testimony if needed. According to petitioner, Mr. Whiteside had spoken with an investigator from the HCRC, Hannah Gilson, on May 27th of 2001 for approximately 20 minutes. Petitioner alleged that during the brief interview, Mr. Whiteside stated that he was not on board with juror number 7 staying on for the final jury, and this was for financial reasons. Contrary to juror number 7's representations to the trial judge and the testimony at this evidentiary hearing. Pursuant to standard HCRC practice, after interviewing a potential witness, investigators add the statements obtained from the witness to the draft declaration. Original notes are not kept once the statements are memorialized in the draft declaration. Once interviews are completed, the witness is then asked to review the draft declaration and correct any errors. Although Mr. Whiteside initially agreed to meet with the HCRC investigator, again, subsequent attempts to speak to him then were unsuccessful, and consequently, HCRC's draft declaration was never reviewed, finalized, or signed by Mr. Whiteside. Petitioner complained during the 2022 evidentiary hearing that he was having problems serving Mr. Whiteside with any subpoena. Petitioner was given additional time to secure service on Mr. Whiteside. Eventually, service was complete on the evening of March 3rd, 2022. Petitioner informed the court that unless Mr. Whiteside voluntarily spoke with counsel before the evidentiary hearing resumed on March 24th, he would not call him to testify. Ultimately, the petitioner didn't call Mr. Whiteside as a witness, and neither so did the respondent. Mr. Whiteside's testimony is directly relevant to 3 points. First, it's relevant to his alleged agreement to carry the financial burden brought by juror number 7's service if selected on the Scott Peterson jury. Second, it was relevant to the September 23rd, 2000 incident with Mrs. Kinsley and the aftermath that followed. And third, it was relevant to the it's driving me nuts, you guys. I am so sorry. Relevant to the purported domestic violence incident in 2001 and Mr. Whiteside's reason for entering his guilty plea. In the court's view, Mr. Whiteside was a logical witness to call where petitioner sought to introduce doubt regarding juror number 7's motives for wanting to be on the jury and to undermine her credibility regarding her account of certain events that transpired. The same, however, could be said for the respondent, whose burden it is to rebut the presumption of prejudice that was established in this case. Okay, we got a couple footnotes in petitioner's post-hearing opening brief. Petitioner challenges and attempts to undermine juror number 7's explanation for failing to disclose the Whiteside incident, that it was she who hit Mr. Whiteside, by arguing that her explanation was inconsistent with number 1, juror number 7's conduct in 2001 by refusing to exculpate him. Fair enough. Number 2, Mr. Whiteside's conduct in failing to ask her to testify on his behalf. Mr. Whiteside pleading guilty. The false imprisonment and endangering the health of a child charges that were subsequently brought against him at the same time. And all of the contemporaneous police and court records regarding the incident that back up the notion of domestic violence. Number 43, the court declines respondent's invitation to draw any adverse inferences under Evidence Code 412 for petitioner's failure to call Mr. Whiteside as a witness. Petitioner's decision not to list or call Mr. Whiteside was a judgment call. Moreover, as stated above, respondent could have just as easily called Mr. Whiteside as a cooperating witness, given that it was respondent's burden to rebut this presumption of prejudice. In either case, Mr. Whiteside's testimony would have either confirmed juror number 7's testimony on these 3 subjects or not. Consequently, the record evidences as to what happened the night of the alleged domestic violence incident is limited to juror number 7's testimony, which the court finds credible. Juror number 7 describes the incident in a very matter-of-fact manner, accepted responsibility for hitting Mr. Whiteside, and with the court's permission was graphic in the language that she used in describing when the police came to her home after what Mr. Whiteside had called them. Moreover, looking at the record as a whole, the court cannot help but note the semblance between the motives underlying the Kinsley incident and the Whiteside incident. While the court does not condone violence for any reason, the record's clear that due to his ongoing infidelity, Mr. Whiteside was physically attacked by 2 women whom he was romantically linked, juror number 7 and Miss Kinsley, in the span of little over a year. Petitioner also contends that juror number 7 is not to be believed because it was Mr. Whiteside who was arrested, charged with the crime of domestic violence and child endangerment, who pled to a misdemeanor charge thereof, and who was required to attend domestic violence classes. On its face, petitioner's argument has great merit. Juror number 7 testified that she knew Mr. Whiteside was the one who was arrested that night, but she also testified that she was not aware of the charges or the fact that Mr. Whiteside ultimately entered a guilty plea. Moreover, the arrest and subsequent plea of Mr. Whiteside should be put in the context of time. In 2001, Mr. Whiteside was a black man in his early 20s living in East Palo Alto with a woman who appears to be white. When the police arrived, juror number 7 answered the door and told them to get the fuck out of my house because I didn't call you. When juror number 7 was asked about a cut on her lip, she did not offer any explanation and told the police officers that she did not know what happened to it. Today, it's well known and a well-studied fact that there has been a historical bias in policing. Training is ongoing to address racial bias in law enforcement. It is therefore not unreasonable to conclude that because of his age, race, and the fact that juror number 7 had blood on her lip, Mr. Whiteside would be the one who was arrested. It is also not reasonable or unreasonable that Mr. Whiteside simply accepted a plea rather than fight the charges given both his quote-unquote complicated relationship with juror number 7 and the existing racial bias in the justice system at that time. And for all these reasons, the court finds credible juror number 7's testimony that she was the one who hit Mr. Whiteside and that he, quote unquote, never touched her. Finding of fact number 3. Juror number 7 volunteered undisclosed information to petitioner's investigator. Petitioner argues that juror number 7's lack of cooperation in voluntarily coming forward after trial to reveal the previously undisclosed information in her questionnaire supports a finding that the non-disclosure was indeed intentional. Harkening back to the law in that first section we started reading today that quotes that intentional concealment is a strong proof of prejudice. Petitioner contends that additional post-trial conduct of juror number 7 supports their argument. That conduct includes, number 1, juror number 7 refusing to speak with the defense or the respondent. Number 2, juror number 7 hiring a lawyer, and number 3, her refusal to testify at the 2022 evidentiary hearing absent a grant of immunity. Setting aside the case that they're citing for facts of law from prior and the instant case and the instance case both involve similar explanations for the non-disclosures, the circumstances post-trial here are distinguishable. First, there was no post-trial questionnaire in the case as there was in Marquise. Okay, so let me just give you that case. So apparently Cliff Gardner, whoever wrote this, whoever was arguing it, it could have been one of the others, argued Enri Manriquez, and so they are distinguishing that case right here, so it is going to come up, so I apologize. 10 years passed between petitioner's guilty verdict and death sentence and the first time petitioner's investigator from HCRC sought out juror number 7. Most importantly, and contrary to petitioner's assertions, juror number 7 did speak with his HCRC investigator when invited, and juror number 7 was candid in her responses. Juror number 7 spoke with petitioner's investigator on November 2nd, 2015. And though juror number 7 could not really recall the specifics of that discussion, she did recall telling the investigator that, quote, restraining orders don't do any good, unquote, and that she, quote, dropped all charges against Miss Kinsley, unquote. Petitioner does not argue, nor did he put forward any evidence that juror number 7 refrained from discussing the Kinsley incident and the civil lawsuit when asked, or otherwise failed to answer any of the investigator's other questions. And based on this record, the court does not draw any inference of bias from the fact that juror number 7 refused to speak a second time with the defense investigator after that misconduct claim was made. Petitioner filed his habeas petition on November 23rd of 2005, 3 weeks after the HCRC's first interview with juror number 7. Juror number 7 testified that at the same time she spoke with the investigator, she was unaware whether petitioner had filed any paperwork that had accused her of anything. Once it was made public, however, the amount of publicity that follows this case and the negative connotations that the accusation of jury misconduct carried all adds to the court's understanding of why juror number 7 would hire an attorney. In other words, it was unreasonable that when juror number 7 found out she was being accused of misconduct, that she would then refuse to speak with petitioner's investigator a second time and would instead seek the services of a lawyer. The court also rejects petitioner's argument regarding juror number 7's request for immunity. First, the facts underlying the juror number 7's decision to seek immunity are not part of this record. Second, there is no basis for the court to draw any adverse inference simply because the request was made by juror number 7 or that immunity was ultimately granted by the district attorney. For all these reasons, the court does not find juror number 7's behavior after the jury misconduct claim became public to support a finding that the original non-disclosure on the questionnaire was intentional.